Vacancy in the office of president. A vacancy in the office of the president may be caused any of the following ways: on the expiry of the term of 5 years, by the death, by the resignation, on his removal by impeachment, otherwise on the setting aside of his election as president. Article 65. When the vacancy is going to be caused by the expiration of the terms of the sitting of president and election to be filled, a vacancy must be completed before the expiration of the term. Article 62(1). But in order to prevent Ittringum owning any possible delay in such the completion, providing that the outgoing president must be continued to hold office, or not wishing that is the term has expired until the successor enter upon his office. Article 56(1)(c). There is no scope for the vice president getting a chance to act as president in his case. In case of vacancy arising by the reason of any cause other than the expiry of a term of the incumbent in office, an election to be filled, vacancy must be filled as soon as possible after, and in no case later than 6 months from the date of occurrence of the vacancy. Immediately after the vacancy arises, say the death of president, and until the new president elected as above, is the vice president who shall act as the president. Article 65(1) is the needless to point out the new president who is the elected shall be entitled to the full term of 5 years from the date he entered upon the office. Apart from the permanent vacancy, the president may be temporarily unable to discharge of the function owing to absence from the India, illness, or any other cause. In case vice president shall discharge of function until the date on which president resumes his duties. Article 65(2). Election of vice president, like that of the president, shall be indirect and in accordance with the system of proportional representative mean of the single transferable vote, but the election shall be different from that of the president insomuch as the state legislature shall have no part in it. The vice president shall be elected by an electoral college consisting of the members of both houses parliament. Article 66(1). As the case of president, in order to qualify to be elected as the vice president, as a person must be qualification for election of vice president. Vice president person must be a citizen in India in completed 35 years. He must not be hold an office of profit save the president, vice president, governor, or minister of the union or state. Article 66. But while in order the president, a person must be qualified for the election, such a member of house of the people. In order to be vice president, he must be qualified for the election as the member of council of state. The reason for this distinction is obvious, namely the vice president normally to act as the chairman of the council of state. Whether member of legislature may be become president for the vice president. There is no bar to the member of the union or state legislature being elected president or vice president, but two offices cannot be combined in one person. In case of member of the legislature elected president or vice president, it shall be deemed to be a vacated seat that house of legislature to which belong on the date of which and enter upon the office as a president or vice president. Article 51(66)(2). Term of office of vice president. Term of office of the vice president is 5 years. His office may be terminate earlier than the fixed term, either the resignation or by removal. A formal impeachment is not required for this removal. He may be removed by a resolution by the Council of State passed by the majority or its member and agreed to House of Peoples. Article 16 provision B. Though the no specific provision to a corresponding or Article 57 making a vice president eligible to re-election. The explanation of Article 66 suggests that a string vice president eligible to re-election of Dr. Rajya was in fact elected second term 1957. A vice president is the highest dignitary in India, coming next to the president. See table 9. No function of vice president. No function are, however, attached to this office of vice president, as much the normal function of the vice president is to act the ex officio chairman of the council of state, but there occurs may be a vacancy in the office of the president of the reason of his death, resignation, removal. Otherwise, vice president shall act the president until new president elected and enter upon the office. Article 65(1). The Vice President shall discharge of function by the President during the temporary absence of the President, illness, or any other cause by reason on which he unable to discharge of function. Article 65(2). No machinery have been prescribed by the Constitution to determine when the President is unable to discharge his duty owing the absence from India or like cause. It become a somewhat delicate matter as who should move is the matter on the any particular occasion. It is the noted this is the provision of the Constitution has not been into use prior the 20th June 1960 through the President Dr. Rajendra Prasad had been absent from India in a considerable period during the foreign tour year of 1958. It was during the 15-day visit Dr. Rajendra Prasad to the Soviet Union June 1960 that for the first time the Vice President Dr. Radhakrishnan was given the opportunity of acting the President owing to the inability of the President discharge of his duty. The second occasion took place May 1961. The President Rajendra Prasad became seriously ill and was incapable of discharging his function. After a few days of crisis, the President himself suggested that the Vice President should be discharged of the function of President until the resumed his duty. It appears that the power of determine when the President is unable to discharge his duties or when he should resume his duties has been understood to belong to the President himself. In the event of the occurrence of the vacancy in the office of both the President and the Vice President, reason of the death, resignation, removal, etc., the Chief Justice of India, or in absence of senior most judges of the Supreme Court available, discharge of function until new President is elected. In 1969, when the death of Dr. Zakir Hussain, Vice President Dr. B.B. Giri, Dr. Hidayatullah CJ discharge of function 20th July 1969 to 24th August 1969. Emoluments. When the Vice President acts as the own discharge the function of President, he gets the emoluments of the President, otherwise he gets the salary of Chairman of the Council of State. When Vice President thus act as the discharge of function of the President shall case of the perform duties of Chairman of the Council of State when the Deputy Chairman of Council of State shall act as the Chairman. Article 91. Doubts and disputes relating to the connected with the election of President and Vice President. Determination of doubt and dispute relating to the election of President and Vice President dealt with the Article 71 follows. The such issues shall be decided by the Supreme Court whose jurisdiction shall be exclusive and final. No such dispute can be raised ground of any vacancy in the Electoral College when elected President and Vice President. If the election of President and Vice President is declared void by the Supreme Court, act done by him prior to that of such decision of the Supreme Court shall not be invalidated. Barring the decision such the dispute, other matters relating to the election of the President and Vice President may be regulated by law made by Parliament.